Okay, and the next speaker will be Mr. Dunn.
Good afternoon. I was just going to say, for those of you who are up till 2 in the morning watching the Longhorns, I'll try not to startle you. As you've heard, my name is Chad Dunn. I'm a civil rights lawyer in Houston. I handle all kinds of cases, a lot of the voting and civil rights cases. I'm also handling the largest case of sexual assault victims against Baylor University right now, a large case for public corruption and bribery against some Houston Independent School District officials, and cases all around the country of various types. But there's probably no type of work that I do that I'm more excited, more involved in, more passionate about than voting rights and civil rights. And so one of the things that I wanted to talk to you today about, when I was invited to talk to you about, is the voter ID case, which I had the pleasure of being one of the lead trial lawyers in the case, both in the trial in Washington, D.C., and then there was another one in Corpus Christi, and I also had the pleasure of arguing the case not once but twice at the Fifth Circuit, including the most recent argument that resulted in some improvement to the law. But before I get into that, I do want everybody to know that I'm just part of a huge army of people, as Nancy mentioned, that made this success possible. And that includes the Brennan Center, as it was mentioned, at NYU, the Lawyers Committee, Texas Rio Grande Legal Aid, the Department of Justice, and NAACP Legal Defense Fund, and scores of other just fabulous lawyers. And so all of them deserve credit for what we have been able to accomplish so far in voter ID. So after I talk about voter ID, I'm going to get a little bit into discussion about redistricting, and what I found is, the fight scene, so to speak, of this performance, redistricting maps, which seems to wake people up. So for some of you who are resting from the football game, I might give you a subtle warning when we get to the redistricting maps. But for now, I want to start off with historical methods of voter intimidation. And a lot of these things have been blocked in various ways by the Voting Rights Act. And I could go through this list, but while we're talking about rights, I do want to share that you have some rights. You have a right for me to not sit here and read every one of these slides to you, okay? You have a right to not be bored until you're sleeping, okay? And you have a right to not have some crazy animations going on here. So I'm not going to walk through each of these in particular, but I do want to talk about some of the things that are going on today in Texas and, as you've heard, around the country. And that includes what is I consider to be a modern-day poll tax, this voter ID law, because of the time, money, and effort it takes to get the ID. And also literacy tests, which I also consider the voter ID law to be, because of the dodge and hustle and the forms and the bureaucratic headache people have to go through to get one of the so-called not free IDs. And then, of course, we still have felon disenfranchisement in Texas. We have state representatives in congressional districts in Huntsville, for example, that wouldn't be there if we weren't counting the prison population of the major state prisons. And unfortunately, most of these techniques are still used to some degree. We have restrictions on voter registration in Texas that are just embarrassing. And as you know, many of you are deputy voter registrars. The type of criminal offenses the state has put on people like you who are being great Americans trying to register your fellow citizens to vote, we ought to be embarrassed about it. And I unsuccessfully handled a case at the Fifth Circuit. Unfortunately, we lost, so y'all can throw things at me when we leave here. But on our voter registration restrictions, and all I can tell you is that we're not done fighting. We're going to see if we can try a new round to fix these restrictions. So if you can take us to the next slide, I show this. This is a real literacy test. It wasn't used in Texas. It was used in Louisiana. People see this, and you read some of these questions, and I think what you'll figure out is, despite your education, experience, your ability to read and write, these are really hard to take. And that was the point of the test. The test was really never to find out whether you were literate and therefore able to understand the political issues. The point of the test was so that election officials would have discretion to pick and choose who was going to be able to vote. And of course, often that discretion was exercised on a racial basis. And I think that's a lot of what we see today with the voter ID and how it has to match, and how much it has to match in terms of the name, and how much it has to match in terms of the other details on it. Again, give a lot of discretion to poll workers, and unfortunately, although lots and lots of poll workers are just absolutely great Americans and great Texans, there are a few that take advantage of these things. So if you want to go to the second page of the literacy test. So, I mean, these things are just, you sit and look at them. I've stared at them for hours and I can't get them right. And I only went to the University of Texas, so, I'm not, maybe there's an educational problem, I don't know. Anyhow, let's go on to the next slide. All right, so the Voting Rights Act, you've heard a little bit of talk about that today. It has kind of two main components, what I call the offense and the defense, okay? So Section 5 was the defense. That was the pre-clearance regime. And so what that said was certain states, when it was passed, and Texas, when it was brought under the Voting Rights Act in 1972, thanks to Barbara Jordan and others, had to, if they wanted to change their election laws, they had to go get approval from the federal government through the Department of Justice, or they could file a lawsuit in federal court in Washington, D.C. and convince 3 judges there that they were entitled to pre-clearance of their changes. And in order to get this sort of mother may I, or this permission from the federal government, then the jurisdiction would have to prove that they've analyzed the extent to which it's going to affect minority voting rights. And if they didn't analyze it, or if the data showed that it was going to harm minority voting rights, then permission wasn't granted. Texas and all of its subdivisions, counties, school districts, mud districts, other jurisdictions, all were under this regime until very recently. So that's the defensive provision. We'll talk a little bit more about that in a minute. The what I call offensive provision is Section 2. And Section 2 says that all discrimination in voting that harms minority voting rights can be, there's a cause of action to stop it. And plaintiffs are entitled to an injunction and other remedies to prevent it from going forward. And so when we file lawsuits, and when Nancy mentions some of the lawsuits that she's talked about today, oftentimes one of the central claims is a Section 2 Voting Rights Act claim. Section 2 applies nationwide to any jurisdiction, including Texas, and it's still alive and well today, thank goodness. Section 5 is the one that we've seen drawn back by a recent Supreme Court ruling, which we'll get to. So if you want to go to the next slide. So Shelby County versus Holder was a case with the U.S. Supreme Court, and Justice Roberts decided that Section 5, the coverage formula for it, was based upon African American voter registration rates in the 1960s and with respect to Texas, Latino voter registration rates. And the Supreme Court decided on a 5-4 basis that that formula was too old, that it needed to be updated for current trends, and that in some places there had been substantial improvement in African American and Latino registration. And so when the Supreme Court said that formula was invalid, then what that meant was no jurisdiction was any longer covered by Section 5, this defensive mechanism. And Congress had to adopt a new formula. But given that Congress is having a hard time naming the post office at this point, as you can see, there's not much that's happening in voting rights. And that's the important bill that Nancy was telling you about, the Voting Rights Act amendment. So we'll go to the next slide. So after Shelby County came down, a number of things happened. Texas voter ID, we had stopped in a Section 5 trial in Washington, D.C. that Nancy and I participated in, and 3 judges ultimately ruled for us and said the law wasn't to pre-clearance. So the day Shelby County was decided, I was actually in the Supreme Court chamber, as was, I think, the vast majority of the civil rights bar in the country. And I saw people weeping as if they had just lost a child, because all of us in the audience knew exactly what was going to happen. And I'm confident that Justice Kagan and Sotomayor were also emotional about it, as Justice Roberts read what we knew was going to be disastrous for voting rights. And so as I walked out into the lobby and checked out my phone, because they don't let you take your phone in there, and you turn that on, you come down the steps, you look at the Capitol building, and you have your Mr. Smith Goes to Washington moment. I opened my phone, and Greg Abbott's texted, then Attorney General, voter IDs now in effect, and would be used for elections coming in just the following days. Now, what had been said is that the state was going to spend a year rolling out the law, was going to spend millions of dollars educating the public, but after Shelby County, it went into effect in a couple of days with no money spent at all. Other jurisdictions like Galveston County decided to eliminate their Justice of the Peace and Constable districts that African American and Latino citizens in that county had the ability to elect. The city of Pasadena, no, not that one, the one in Houston that's a little bit warmer and the air smells a little bit different. That city has long been controlled by whites on the city council, but for some time, Latinos have been a majority in the community, and they're approaching 50% of the majority of citizens of voting age. Despite that and a number of suppressive efforts, whites have kept control of the city council, and the city council has now decided to go to at-large districts instead of redistricting in order to make sure they can stay in charge, even though they are now essentially governing the Latino community. The Beaumont Independent School District, which is a majority black, both in population, voting population, student population district, It didn't ultimately get majority black representation until the late 80s, thanks to a federal court order. As soon as Shelby County went into effect, it lifted an injunction against the school district, and a state court ordered the school district to go to partially at-large elections, which will ensure that whites stay in charge of a majority black school district in Beaumont. And of course, you've heard about North Carolina and Alabama, and what we're about to see, I'm afraid, and I hope I'm wrong, is one polling place after another closed without the ability to stop it. The beauty of the Section 5, the defensive mechanism, is that when jurisdictions wanted to close a polling location, they had to go get permission from the government. That took time. So you couldn't just do it right before early voting starts or halfway into early voting or right before Election Day. And now in Texas, they can. So, this isn't something that I think we have to worry about in Travis County, but unfortunately there's a lot of other places we do have to be concerned. All right, let's go to the next slide. So we talked a little bit about the remaining rules. We have Section 2. We also have intentional discrimination claims, which we used in the voter ID case. One person, one vote claims, which you heard Nancy talk about. And Shaw versus Reno claims, which I think are out of favor. I won't spend time talking about those. But I do want to talk a minute about political gerrymandering claims, because somebody asked the question about who represents the political parties in this thing. So the political parties for some time, both sides in different jurisdictions, have argued that there ought to be a claim when the legislature, the school board, or the government officials say, we're going to draw these districts, or we're going to make this election change because we want to make it harder for Democrats to vote, or because we want to dilute the vote of Republicans. And people like me think that ought to be a First Amendment violation. I mean, after all, after Citizens United, if I give $1 to somebody or $1 million to somebody, the government, I have a First Amendment right to do it, and it's subject to strict scrutiny if the government wants to stop me from doing it, which means the highest level of judicial scrutiny. But when it comes to voter restrictions, we're supposed to do this sliding scale, where we look at the government's interests and the voters' burden, and we decide if maybe they line up. So it's a much more loose restriction. And there hasn't been, until recently, a good objective measure of political gerrymandering. How do we know? I mean, look, every legislature that's has a majority, that majority is going to try to do damage to the other political minority, and maybe racial minority, but certainly political minority. So some various academics have come up with some mathematical formulas to use in political gerrymandering cases. There's two cases I know of, one that was just tried in Wisconsin that's going to go to the Supreme Court. It's a 3-judge court case where the Supreme Court may decide that it's also unconstitutional to discriminate based upon viewpoint. And if that happens, it'll really be a whole new world. We'll have racial discrimination claims and political discrimination claims, and in places like Texas, those things often overlap. All right, so next slide, please. Bail-in that you heard Nancy talk about is if we can prove in court and we can get a court of appeals to affirm that a given election change was intentionally discriminatory, which is what the courts found on the voter ID law and what the courts have found so far on Texas's statewide redistricting plans, then the state gets forced back under the defensive mechanism that I talked about, the Section 5 provision that says you can't make any changes to your election laws without proof. So bail-in is a critically important thing for those of us who are worried that Congress won't ever act to amend and come up with a new coverage formula. Another way we can get jurisdictions who need it covered is through litigation. And that's going to be the next step in the voter ID case. So if you go to the next slide. These are the factors that you use to prove intentional discrimination. And, obviously there's a lot, we could spend the whole day talking about how you prove intentional discrimination, but one of the things I want you to note is that it's not that you have to go find some legislator says, yeah, I'm a racist and I wanted this bill. That's not how it works, okay? You can find it by indicative actions by the legislature, by their emails and by their contemporaneous communications, and by how they structured things. So for example, in the voter ID law, there are 6 IDs in Texas that you can use to vote. All of them are disproportionately held by whites. And then IDs that are disproportionately held by African Americans and or Latinos were specifically rejected when the legislature knew that those IDs were just as reliable as the ones that they selected and knew the racial disparity in the ID possession. So to give you an example, the Texas Department of Public Safety issues some 200 or so IDs, including the driver's license and state ID some of you have. They also issue IDs for the University of Texas, and the University of Houston, and the Department of Public Safety, and the Texas Department of Health, and the School for the Deaf, and on down the list. And all of those IDs are disproportionately held by racial minorities, but the legislature said you can't use those, even though they're created by the same office, same department, same system. And so that's one example of how we can show the legislature knew what it was doing, and why it was doing it. So, if you go to the next slide. I want to start this off because, we talk about the legacy of discrimination in the South, and I don't think anything can show it more than this. This is excerpts from a report that we offered into evidence in the voter ID case that shows the disparity in education and income and vehicle access. And, those figures exist because we made it so. I mean, I love my state, but we don't always do the right thing here, and we haven't for a long time. And we've designed educational systems, transportation systems, housing systems, governmental regulations that have been designed to improve the condition for Anglos and damage it for other parts of our community. No question we've made progress. No question that many of these things have been rightfully banned under our laws. But that doesn't mean that the residual effect of them isn't still around. And that's what the voter ID fight was about. I mean, what I tell people is what separates us into a civilized society rather than barbarians and savages is our ability to understand another's condition without having to stand in their shoes. And although all of us, or many of us in this room, have IDs, we fly, we drive, we do these things, I've seen them. I've sat in their living rooms. I've put them on the witness stand. There are 680,000 registered voters in Texas who don't have one of these IDs, and they don't need them. And they wouldn't get one unless the government made them. And a lot of them are veterans, a lot of them are your neighbors, a lot of them are people who work on your house and work in your grocery store. And we have to be sympathetic and understand that their civil rights are as important as everybody else's. And if you go to the next slide. So in voter ID, here are the documents that you could use under state law, and you are still required under Texas state law to bring one of these IDs with you to vote if you have one. So if you have an ID, go vote and bring it. And if you don't, and you tell the election worker, I have it, but it's at home, they're going to make you go get it. And if you don't want to go get it, then you're going to vote provisionally, and you're going to have 6 days to bring it back. So if you have ID, you have to use it after this rule. All right, go to the next one. So this is the trial in Washington, D.C., where we first convinced these 3 federal judges sitting there not to pre-clear Texas's voter ID laws. It took place in 2012. The Supreme Court the Supreme Court wasn't in session that day, so we came over and sketched this out. And that's actually me at the podium taking testimony from Wendy Davis about her efforts to make the voter ID law. And this kind of gives you a sense of what these scenes look like. I mean, packed lawyers out in the hall, media out in the hall. A lot at stake here, and a lot of minds at work on both sides. All right. So one of the things that Wendy Davis testified to were all these amendments, and this is just a share of them, but there were amendments just to have the Secretary of State track the number of people who didn't have an ID, just so we'd know, and keep track of them by race. And the Secretary of State's office wouldn't do that. The legislature struck down that amendment and said, we don't need to hear that information because we know what it's going to show. We've designed this thing pretty well, and we're pretty convinced it's going to disenfranchise blacks and Latinos. And there's no sense in having some reports later that tell us that. On top of that, there was a lot of efforts, as I mentioned, to add additional IDs, to deal with provisional voting. Again, amendments, I think it was over 100 amendments, ameliorative amendments, we call them, were rejected. And again, that's evidence of intent. All right, next slide, please. So just to give you a sense of, this is the city of Houston, the little balloons are DPS offices, places where you can get a so-called free ID that's not free. And as you'll see inside the 610 Loop, which is the central business district of Houston, which also contains a lot of racial minorities, there's no place to get an ID. The closest place is up on 290 in Tacoma, which is also one of the busiest locations in the state with an average 2-hour wait. So what we would do is we'd talk to people who didn't have ID, and we put them on buses. And of course, we're paying for this. So a lot of these folks are, impoverished or they're limited means. And we'd say, take a bus up to whatever location, 290 in Tacoma, and they would go and they'd transfer a couple of times, and they'd get there and they'd stand in line 2 hours, and they'd be told no for some bureaucratic reason, and then they'd come back. And this is testimony that we put on in the trial. One of the things I think is so funny is conservatives don't think the government can do anything right, but they do seem to think they can get an absolute grade A, blue ribbon ID possession issuance program together in DPS offices. And if any of y'all have ever been to a DPS office, it's hard to even understand how that might have been conceived. But in any event, if you go to the next slide, this is Dallas, a similar situation. The pin there, the red pin is downtown Dallas Central Business District. And to be fair, the vast majority of the African American population in Dallas County is in the bottom south middle of the county. And so there is one location over here But I'll show you a different racially shaded map here in a second to give you a better sense of this. There's the black population in Dallas County, and you can see there's one DPS office in it. And I should say that's 60-70% black. Obviously, there's Latinos, Anglos, Asian Americans, and others there. All right, let's go to the next frame. This is, we had a question about rural areas, and this gives you a sense of, in what I consider sort of the most densely populated rural part of the state, between San Antonio, Austin, Houston, you still have a sparsity of DPS offices where you can get one of the so-called free IDs that aren't free. And then out in West Texas, you have 60+ counties that have no offices at all, and in some places you have to drive 150 to 200 miles in order to get to an office that can issue these IDs. Now, to be fair to the state did put together this program. I call it the Wienermobile. They would have a couple of trucks that would drive around, and if you could find one or happen to see one on the side of the road, you could flag it over and you could get your ID issued. But there wasn't much to know in advance of where they'd be at, and certainly not something that if you're working 1 or 2 jobs that you could sort of organize your life around. So, all right, if you go to the next. So the D.C. federal court heard a lot of this evidence, and they issued an opinion, and they found that the law was discriminatory in effect, and that in fact there was even evidence that it was discriminatory intent. And so the D.C. federal court said Texas can't use it. That was back in 2012. And so the law passed in 2011 didn't go in effect until Shelby County came down. Next slide. As soon as Shelby County came down, as I said, I walked out of the Supreme Court building. I saw that Greg Abbott had announced it went into effect. I went and, I can't describe it any other way except awake. I mean, you look at these people's faces who fought their whole lives. Congressman John Lewis, who suffered a brain injury fighting for the rights of African Americans. And these folks walked out in tears, and it was emotional. And I went back to the hotel and thought, well, that's it, we lost. And I got angry, because that's what I do sometimes. And I said, well, I'm going to write a new lawsuit, and I'm going to file this thing tomorrow. And so that's what we did. We filed a lawsuit in Corpus Christi the next day, and we brought these 4 claims, and we said, we're going to start over. All right, go ahead. We put on some evidence, and this is, we came up with 3 different methods of determining ID possession, because we wanted to show that it was true that Anglos had much higher incident of ID possession than blacks and Hispanics. And then we went to a survey which showed similar information, and ultimately we were able to convince the court. So I'm showing I'm almost out of time here, and I'm just going to take the last few seconds, and if you'll skip down a few slides, I was going to show you a little bit of the redistricting maps. Keep going. Texas has, there we go, stop right there. This is Senate District 10, Winnie Davis's district, the state Senate district in Tarrant County. And what you'll see here in Senate District 22 is the legislature in 2011 came in and took what is the historic black community in Tarrant County and buried it in a Senate district that goes all the way down past Waco into Falls County, just north of College Station, so that black community's votes would be buried in a largely white rural population. If you go to the next frame, after the lawsuit, we were able to restore Senate District 10 like this, which still incidentally elects a Republican, but has the ability. But blacks and Hispanics in that district had the ability to elect. I'll show you one more and then I'll sit down. This is probably the worst example, House District 41. This is down in Brownsville. It's pretty hard to draw a district in Brownsville that will elect a Republican, okay? But you got to give state credit. We're the best and the biggest at a lot of things. And one of the things that we figured out how to do was draw us a district that would keep a Republican elected. And that's what the product of it was in 41. And in fact, there was evidence in the case that the way the state did it, knowing 41 had to be majority Hispanic under the law, they went around and found Hispanic voting precincts that had very low turnout, but high Hispanic population. So in the figures, it would look like this is a lot of Hispanics in this district, but they knew they were ones who didn't perform or show up to vote. And there was emails to that effect, which is why we ultimately think the legislative maps will be struck down for intent. So anyhow, that's a lot of information, I know, but I hope that's been informative to you. And for those of you who got a good nap in, I'm glad I can facilitate that.
Yeah, we'll open it up for a few questions.
Okay.
I just want to make a correction because that's my district. It's McAllen.
McAllen, I'm sorry, you're right. McAllen,
Like,
not Brownsville.
that happens
That's
in
right.
my district. My
Yeah.
grandma lives across the street. She's in another district, and I'm in another district.
They picked and chose houses. It's crazy. All right, any other questions? Yes, ma'am.
So unless
I mean, there's a current appeal, right, for the voter, that Paxton and Abbott are going to file.
Well, they said that. I've never seen anything like this. The states said they're going to appeal, but they haven't done it. The status of things is that all 15 judges of the Fifth Circuit ruled 9-6 in our favor, and an order's been entered that now says that people can show up and vote with IDs that don't have their photo on it if they have an impediment to getting one. The state says they're going to appeal to the U.S. Supreme Court. I don't know precisely when the deadline is, but it's after the election, so my suspicion is the state's waiting to see how the presidential election turns out, and then will, file its appeal. But it said it's going to appeal, so.
So for the election coming up in November, then the voter ID law is not in effect.
Okay, so for November, here's what the rules are. If you have one of those 6 voter IDs, you have to bring it, okay? If you lost it, and you have and it's easy for you to go get another one, then you got to go get another one issued, okay? But if you lost it, or you've never been issued one, or you've been issued one and it's more than 4 years expired, or you don't have a birth certificate, or you have what's called a reasonable impediment to obtaining another one, then when you go down there, they will say, show me your ID. You can say, I don't have one. And they'll say, well, did you just forget it? They'll say, no, I don't have one, and I have difficulty getting a new one. And they're going to give you a declaration that you sign right there. There's a whole bunch of examples, including other, that you can check off as to your reasonable impediment, and then you get to vote a full ballot, a full regular ballot, not a provisional ballot. So those are the rules right now. Yes, ma'am.
Does it have to be a voter ID?
So if you have a voter ID, one of those 5,
Photo ID.
yes, ma'am. If you have one of those 5 photo IDs, then you have to bring it. If you don't, then you can bring a light bill, utility bill, government document, and they don't have to have your ID. And then you sign this impediment declaration and you vote, okay? Now, one of the things the state said, just to bring it today, is some county officials have alleged that people who fill out these reasonable impediment affidavits, they're going to run these folks through some kind of dragnet of if they find out you probably could have reasonably gone and gotten an ID, they might think about prosecuting you. So we have a hearing tomorrow in federal court in Corpus Christi to get to the bottom of that issue. So we'll have to see what the judge rules on that. Yes, ma'am.
Thank you for getting angry.
Okay. Yes, up there. I can't quite see it.
If by some miracle the gerrymandered districts are declared illegal and they go back to the legislature, what can we expect?
Well, you're not talking to a guy who's got a whole lot of a high degree of confidence in what this legislature does in redistricting. But, the courts are going to supervise it at that point. And that's sort of the point of the Voting Rights Act. Once the court determines that the state committed an error in how it drew its maps, it's going to lay down some rules that say, all right, the legislature, we're going to give you a chance to fix this, but here are some basic parameters that you need to follow. And if you don't do it, then we're going to do it after that. And the court will take over the drawing of the district. So, it'll be a little more like the legislature has an umpire looking over its shoulders as it draws the maps the next go around.
Time for just one more question.
Yes.
So they are looking at those redistricting cases, right? I mean, they only have ruled in the state Senate case, and the other lawsuits are still in play. I understand they were heard 2 years ago. Nothing's happened. Do you have any insights?
Well, I do. I represent parties in the redistricting case, so I can spend 6 hours telling you exactly where the redistricting case is and how it got here, so I'll skip all that. There's been a bunch of trials and a bunch of rulings, and the Supreme Court's changed the law a few times, and so it's a little bit of a 2 steps forward, 1 step back. But the current status is that 3 federal judges in San Antonio have heard 4 trials, I think, at this point, on the redistricting map, and we're waiting on a ruling from them, which we expect probably right after the election. I have no information from the court, but that's my suspicion of when we'll see the ruling. They don't want to issue a ruling now to confuse folks about what boundaries are. The boundaries are fixed for now. There's going to be an election. You pull up the congressional maps, that's what they are. But I think we'll get a ruling right after Election Day, and then I'm assured whoever is unhappy with it will appeal. And because it's a 3-judge court, the appeal to the U.S. Supreme Court automatically, and the U.S. Supreme Court has to rule on it. It doesn't necessarily have to grant argument, but the Supreme Court has to issue a ruling. So those are the steps. I think in late 2016 and early 2017, we're going to see a ruling from the 3-judge court in San Antonio, and then probably a ruling from the U.S. Supreme Court thereafter.